Sanctions 101, I'm going to hand over to Scott McCreary from McAfee and Taft, who's going to moderate David Hernandez from Vedder Price and Mark Bisset from Clyde & Co.
Good afternoon, and thanks Alistair and the CJI team. I think you'll all agree these events are wonderfully put together, and it's such a pleasure to be able to attend them, and they do a really good job. As Alistair said, my name's Scott McCreary. I'm a lawyer with the law firm of McAfee and Taft in Oklahoma City, and I'm moderating the panel today with a very riveting and exciting topic of sanctions. And my two colleagues on the panel here today they really don't need much of an introduction, but I guess that's my job. So we have Mark Bisset. Let me get my notes up here. Mark is a lawyer at Clyde & Co. He's based in London. He's the head of the aviation finance at Clyde's. His practice covers most all of aviation, transactional, and regulatory matters. Interestingly enough, he's the contributing editor of the annual publication Getting the Deal Through Aviation Finance and Leasing, and the co-editor of the publication Getting the Deal Through Air Transport. And David Hernandez is a partner with Vedder Price in Washington, D.C. David is a member of the firm's global transportation finance team. He's also actively involved with the NBAA. He's on the tax committee and the NBA regulatory advisory committee. Prior to joining Vedder, David was also a prosecutor at the FAA, as well as an attorney, an honors attorney, you'll have to explain that, but an honors attorney with the Department of Transportation. So what I think we've seen today, and probably what we'll see tomorrow, is that aviation transactions are complex. I mean, there's a lot going on. You've got to figure out what kind of aircraft you want to buy. You've got to figure out what kind of trips that you're going to make on the aircraft. You need to decide where you're going to register it. You're going to decide whether or not it's airworthy, whether or not the engines are on a plan, are there tax implications and things like that. And so people are really focusing on those things. But one of the things that they don't focus on that much is whether or not, if you do the transaction, you might go to jail. And so what I think today Mark and David will help us with is understanding how to avoid that situation. So with that, I'll hand it over to David.
Okay. Thanks, Scott. This panel, or sanctions, is probably the most serious panel in terms of what will get you in trouble. And as Scott said, it's a situation where it does involve criminal sanctions. And what we're going to go through in the next few slides is just discuss ways to basically understand what the sanctions are and what to do if your clients do get in trouble. We'll flip the slides. Okay. So I'm going to talk about the U.S. export control laws, and Mark's going to talk about EU and other locations. So I guess to put it simply, these type of cases are probably the most difficult ones that I deal with, because the government's philosophy is shoot first, ask questions later. You're presumed guilty. You have to convince the government you are innocent. And you're dealing with one of the most sophisticated data gathering information systems in the world. They always know more than we do. And they have, like I said, very sophisticated data gathering information. And we can all do this test, if you will. Is Paul Jebeli in here? No? Good. So send Paul an email, subject Mahan Airlines engine sale, and just fire it off and see what happens. See how your world will change in the next 90 days. Okay, don't do that. But any text messages, emails, any voice communications can and will be intercepted if you're not a U.S. citizen. That's the data gathering information. I've had cases where the government has called me up and said, David, I think one of your client's planes are in Tehran getting repainted. So what are you talking about? This plane's supposed to be in Turkey. We have video and pictures of the plane sitting on the ground in Tehran. You can't argue with that stuff. It's never going to be good news when you get a call from a couple of these agencies. So what I'm going to do is just go over the basic laws, and I think this bottom, that consolidated search list, write that down, memorize it. If you type in names, you'll get the list of if your clients or potential clients or someone you know is on that list. Stop talking to them immediately. Avoid them, because your life will change significantly going forward if you work with them. So the first one to deal with is the Office of OFAC, or Office of Foreign Aircraft, Asset Control Regulations. The other set of regulations, the EAR, and the third is ITAR, or International Traffic in Arms Regulations. That's military assets. So Office of Foreign Asset Controls. All of these agencies are very, very efficient. So when you think of OFAC, think of financial transactions. These are the folks that control the money. And what's important about this, many of my clients, I always get a call after, well, if your client's on the, I've learned this the hard way, if your client's on the OFAC list, you can't get paid. So, you know, for professionals that are dealing with this stuff, if your client gets tagged on the list, if you have a retainer sees, they can't pay you. It's very difficult. But in any event, this regulation involves trade sanctions against certain individuals, entities, foreign governments, agencies, and people of interest that the government has found a reason. Typically it's terrorism. Very broad financial transactions. And remember, whenever you do a transaction, typically it involves U.S. dollars. Well, folks, every dollar-denominated transaction goes through the United States. So if you've got two international parties and your transactions in dollars, they can seize your money. And I've had that happen where I get a client call up and say, look, $3.5 million was just seized on these aircraft. What happened? And we'll get to that, what happens when you get tagged. You're always it when you're tagged by OFAC. It's game over. So specifically designated nationals, blocked persons list, and there are also country and region-based sanctions. The obvious ones, Cuba, Iran, North Korea, Syria, and even eastern Ukraine now. EAR. So this is the export control regulations that deal with assets typically. Aircraft engines, parts, and typically these involve, what we see more often than not nowadays is people trying to funnel. I mean, it's no surprise, folks. I mean, like I said, you've got the government, the U.S. government, with all this surveillance and data information, and they're tracking everything, virtually everything. So you've got all these shell corporations set up in Turkey and the Middle East and Dubai trying to funnel parts through to Iran. I don't know why people keep doing it, but they're constantly doing it. And there are other regions as well, but you know, these are the most likely export regulations you'll encounter. There's two lists I highlighted in there: entity list and denied persons list. And it's not necessarily obvious folks that are on these lists. And I'll give you an example. Does anyone have a Huawei phone now? Does anybody? Okay. So your Huawei phone will probably stop working in about 60 days because Google can no longer support it. So any Android system that's on there, Google Maps, you're going to get lost if you don't have a backup. Go back to the paper. But in any event, it's a kiss of death. And I just read in the Wall Street Journal, Huawei is going to stop their personal computer line as of today because they don't get the support. That's just one example. Every single client that I've been involved with and put on the entity list has gone out of business. Every single one. Because it's so difficult to survive. You have to get licenses, and the licenses are always enormously slow to get. It takes a long time. Involves aircraft engine support. So imagine if you can't get any support for your aircraft or your engine, your parts, you're done. There is a little carve out there for 10% U.S. content. I've had one example where it was an Airbus A300 with Rolls engines and very little U.S. content that didn't get covered. The people were on the entity list. They eventually went out of business. All this stuff is very sophisticated, so you have to read the regulations. The regulations are hundreds and hundreds of pages. Shorter answer is it's very complex, and these guys shoot first as well and then ask questions later. You're presumed guilty. There is a voluntary disclosure option, so if you are suspected of violating the regulations and you haven't got a call yet from the government, you can voluntarily disclose. That does make it a mitigating factor, but you're still going to get fined. You won't go to prison, but you'll certainly get fined. ITAR, I won't talk about this too much. Unless you're selling military hardware, helicopters typically, engines. If you're selling munitions and weapons, don't give me a call, because that's very difficult to deal with if you're selling munitions and weapons. But a lot of these things, a lot of these regulations got moved over into EAR, the export, the commerce people. And by the way, they have investigators all over the Middle East. Turkey, they have base in Dubai. And so you'll see these people that look like government agents walking around following you, and that's exactly what they're doing. I mean, it's no joke. They're not going to have a coffee with you. They're going to follow you, and they're going to take pictures. It's just like the television. Okay, next one. And so this is where Mark and I will kind of go back and forth. But so in terms of different approaches countries take, the United States is very aggressive. They have a very combined approach. All these agencies work together. So sometimes you could be violating both OFAC regs and the BIS. So they talk and say, well, you know, what's the most effective way to hammer these folks? So they'll go after the financial transactions and seize the assets, and then they'll put you on the entity list. So you'll have no money, and you'll have no one to do business with. You're presumed guilty. Burden of proof's on the person. Criminal, civil, and asset forfeiture. The fines are huge. Grand jury subpoena. I had a client that flew into LAX to visit her grandmother, or no, her mother, and the minute she landed, they slapped her with a grand jury subpoena to meet in D.C. in the following week. She said, you cannot leave the country until you show up, and if you do, we'll throw you in prison. On the export, or not say the export, when she was trying to leave the country on Turkish Airlines, 2 FBI agents walked on board and said, look, and this is after, well, let me preface that. They told her she could leave the country. And we thought that was a little odd. They said, well, look, you don't have to appear for the grand jury subpoena. You can just leave the country as soon as possible. She boarded the plane, Turkish Airlines. She was flying back to Europe. 2 FBI agents boarded the plane and said, look, you've got 2 options. We changed our mind. You need to stay in the United States, or you can give us your computer, all your flash drives, and any type of electronic information, your cell phone. You can get back on the plane and fly home. Well, she was in tears. Of course, she just gave them everything. It's like a data dump. And she went back home. Now she can never come back to the United States because we don't know what's going to happen. That's the stuff you're dealing with. And so this is very serious. And so when you ever deal with this type of stuff, think very carefully. And you know, the violations are there. OFAC, huge numbers, massive numbers. You can read through all of that. EAR violations, about the same. When you see 20 years imprisonment, that'll ruin your day typically. You know, how do you explain that? You just think, what you can't, right? Prison's never a good thing. So, and you can go through the other things, denial of export privileges. The goal, and we'll talk about these in the last 2 slides, what do you do if something does happen? But you know, that's it. I hope I've stressed enough that it's very serious. And if you're thinking about buying a Huawei phone, don't. If you're an American, all right. That's it for me.
Thanks, Dave. It's a pleasure to be able to speak today, and it's nice to be able to be invited not to talk about Brexit for a change. I'm sure we'll be able to shoehorn in Brexit at some point during this discussion. And that's good in the sense that Brexit will come, and go. Brexit will be done at some point. But economic sanctions have been with us for 2,500 years since the Peloponnesian War, and are going to be here forever. And I'm sure a lot of people have noticed over the last few years, there's definitely been an attempt by governments, certain governments, to use sanctions as another method of economic warfare, which is becoming more prevalent as an alternative to proper warfare. So, whether this be trade policy, imposition of tariffs, or the imposition of sanctions. So this is only going to become a more and more topical and relevant topic. As Dave says, and I obviously completely agree with everything Dave says, we tend to do a double act these days, and other commentators and agree with each other. It's a very complicated area. It's very fact specific, and those 2 points, if nothing else, lead to the very self-serving statement that on this topic, if nothing else, you need to take, if you think you have any sort of an issue relating to sanctions, you need to take legal advice. Because, as Dave's mentioned, the consequences of getting this wrong are extremely draconian, extremely large fines, reputational damage, people going to jail, etc., etc. It's an extremely serious issue. I'll just summarize very quickly the EU sanctions, and then I just wanted to have a look at some examples of sanctions in practice, or cases that I've had in practice. Broadly speaking, the EU sanctions regime, as you may expect, is broadly similar to the United States. It's binding on all persons. The most important point on this slide really is that it's binding on all persons or entities doing business in the EU, including nationals of non-EU countries, and also the EU nationals when doing business outside the EU. So an EU national doing business in Singapore would be subject to EU sanctions. A US national doing business in the EU would be subject to EU sanctions. So it's very important to sort of think it's not just similar to the US regime, which is very international. It's not just the case that if you're outside the EU, you can forget it. It's directly relevant to any EU national, regardless of where they're doing their business. Very broadly, the systems are roughly the same. In business jets, I'll concentrate on the list-based regimes for business jets, because I think that's most directly relevant to what we do in practice, which is asset freezes, travel bans, and prohibitions on making available funds or economic resources to what in the EU regime, as well as in the US regime, are called specially designated nationals. Scott. One very important spin, though, in the EU is that we have what's called the EU blocking statute. This has existed for about 20 years, but it became particularly well known in August last year when President Trump reimposed sanctions against, very swinging sanctions against Iran. In the EU system, there's a blocking statute, which means that EU nationals cannot do anything which goes, well, basically can't comply. It says must not comply with US sanctions if there is no EU equivalent, or if they'd be doing something against EU interests. It's quite a complicated statute, but in very broad brush terms, it puts EU nationals in a very difficult position where they may wish, for various reasons, reputational, etc., to comply with US sanctions, but there's an EU blocking statute which says, actually, you can't do that. So, as I say, it puts EU entities in a very difficult position, and you see them in practice trying to get out of this very difficult position in quite tortuous ways. So, for example, when the US did reimpose sanctions on Iran in August 2018, it suddenly became illegal, for example, for airlines to fly to and from, commercial airlines to fly to and from Iran, because they can no longer get a temporary sojourn exemption. But then you also then saw EU airlines stopping to fly to and from Iran, even though it wasn't actually then illegal for them to do that. And under the EU blocking statute, they shouldn't have stopped. So you see, not naming names, but you would have seen airlines issuing statements saying it's no longer commercially viable for us to fly to and from Iran. No airline came out and issued a statement saying, because of US sanctions, we're stopping flying to and from Iran, because that would have gone contrary to the blocking statute, which also has consequences itself, which are fines. so, commercial reality dictates that some entities follow US policy even when they don't actually have to. And as David's rightly said, that's because the OFAC has an extremely broad jurisdictional reach, encompassing, last bullet point there, foreign persons to the extent that they involve a US transaction. So it's probably about as broad as you can get. And Dave's absolutely right. No one wants to upset OFAC. Can we use the word aggressive? Use the word aggressive.
Yeah, aggressive.
Yeah, aggressive. That said, you can have a conversation with OFAC. You can, in practice, we have had open discussions with them on certain issues and got a very good steer from OFAC as to whether they would have an issue with certain transactions that you're doing. Conversely, I had a client that was trying to sell an aircraft to a gentleman in Kazakhstan, and we were rung up by OFAC, well, the client was rung up by OFAC, who were basically saying, you don't want to do that transaction, that gentleman is a front for Iran. Which is, when you think about it, as Dave's alluded to, pretty scary, because no one from our side or from the other side had contacted OFAC to ask what they thought about this transaction. They just happened to have found out about it. And that is pretty scary. For non-US persons, so the general theme there is for non-US persons who may not be directly breaching US sanctions, that they nevertheless got to think extremely carefully about it and extremely carefully about whether they want to comply with US sanctions policy. That's a matter of their own internal policy, because the consequences can be pretty severe, and I've listed them there, but the bottom line is really you're frozen out of the US financial system, which for many businesses is just the kiss of death. That you're not going to survive very long in business if you can't, for example, route dollar payments through New York. I'll just very quickly have a look at one example of EU sanctions in action, which is Russia. EU sanctions against Russia obviously have been ramped up over the years because of the situation in Crimea and Ukraine, and includes travel bans, asset freezes. These have been in place since Regulation 2006-9 of 2014. So if, in terms of specially designated nationals on the Russia list, they are listed in an annex to that regulation, which is supplemented monthly. There's also, I should have put up the link, similar to the OFAC link. There's an EU link where you can check specially designated nationals, not just for Russia, but for all the EU regimes. And I said that's also updated monthly. It can be quite difficult in practice, because you may be dealing, various countries have individuals with different variant names, especially say in the Middle East, and you may be dealing with individuals without being entirely certain, even if you look at the list, as to whether or not that individual is or isn't sanctioned. It's never as easy as just looking at the list and thinking, oh yeah, he's not on, so he or she is or isn't on. You have to really delve into that person, look up the internet, look up more, try and find out more detail than maybe just apparent from the list itself. The Russia regulation, applicable in all EU member states directly because it's a EU regulation. It's the essence of what we'd be dealing with in terms of specially designated nationals, and that says you cannot make funds or economic resources available. Sorry, the first one, 2.1. All funds and economic resources of a specially designated national must be frozen. And I'll come on to some examples in a sec. And Article 2.2, no funds or economic resources shall be made available to a specially designated national. So, just a few examples to finish of what sort of situations we can have in practice. Here's a high net worth individual, 100% owns a Cayman SPC which owns an aircraft, and that Cayman SPC is contracted with an EU operator to manage the aircraft on its behalf. If you had a situation where that high net worth individual goes on the EU specially designated sanctions list, because he 100% owns that Cayman SPC is also then caught by the specially designated list. I mean, that's kind of obvious. It's a wholly owned subsidiary. That would mean that the EU operator in that circumstance should has to, unless it wants to commit a criminal offence, freeze the aircraft, i.e. ground the aircraft, freeze any deposit it's got under the management agreement, not receive payments, etc., etc. So we've had this in practice, and it's almost like instantaneous shutters down on that aircraft. It's not going anywhere. So, back.
Another one?
Then back to the first one.
Go back. Okay.
So, but even if that high net worth individual, say, was only on the US sanctions list but not on the EU sanctions list, and we've had cases like that, there are certainly individuals on the US list but not on the EU list, the EU operator's still got a problem, not least because so many transactions in relating to aircraft are made in dollars, are paid for in dollars. And if that EU operator might be facing a situation where if it basically can't receive dollars without those dollars being any attempt by the Cayman SBC to make a dollar payment, that dollar payment should be frozen in the New York banking system. And if the EU, worse for the EU operator, and I'll raise the dreaded word facilitation, worse for the EU operator is if it receives a dollar payment in those circumstances, it would know for sure that that dollar payment should have been frozen in the New York system and hasn't been. And if it receives it, in our view, it would therefore be facilitating a breach of sanctions. Example number 2 is very, very quick, but just to make the point that, because we've had this one in practice, say in this circumstance, high net worth individual 1 goes on sanction list, but the other 2 don't, and they jointly own the Cayman SBC, which, as I say, we've certainly had in practice. The Cayman SBC in that circumstance would not be subject to sanctions because it's not wholly owned by the sanctioned individual, or majority, sorry, the test is majority owned, so more than 50% owned. But again, EU operator might have some serious consideration as to whether, from a risk perspective, it wants to, reputational perspective, it wants to be dealing at all with somebody who's sanctioned. You also have situations where you can have family members who are, say, the owners of the Cayman SBC in this circumstance, wives, children, etc. And broad brush speaking, sanctions, especially the US sanctions regimes, tend to include or make reference to immediate family members. So if your Russian high net worth has sold the aircraft, sold his shareholding in the aircraft owning vehicle to his wife the week before, and then suddenly goes on the sanctions list, that's not necessarily going to get him off the hook. Oh, a Swiss banking example, with apologies to all Swiss banks in the audience. I should be very careful what I say since I act for a Swiss bank. So, but let's take the example of a Swiss bank. If the high net worth individual in this case goes on, let's say, the EU list, the Swiss bank has to ask itself, is it even subject to EU sanctions? Maybe, and there is, some legislation in Switzerland that says thou shalt not do anything to breach US or EU sanctions, even though we don't have the equivalent in Switzerland. So you can see how it turns into a very complicated area. The Swiss bank might say, because we do international business, are going to comply with EU sanctions as a matter of internal policy. We might say that we're going to be complying with US sanctions as a matter of policy. It would be a very sensible thing to do. No one wants to annoy the United States. But then it puts it in a very invidious position, because if merely by policy you're complying with sanctions, does that mean that legally in your contracts you have the advantages or disadvantages or the rights that you should have? So I won't label on any examples in relation to this, but there are many issues in relation to this in relation to financing. If a bank repossesses an aircraft, what can it do with it? Does it have to freeze it? Can it even repossess it at all? Does it have to go to an authority to get approval to repossess it? If the Cayman SBC here tries to repay that loan in making a dollar payment, is the bank obliged to receive that payment? If it receives it, is it obliged to freeze it? Again, if that payment went through the New York banking system in circumstances where the bank knows that it shouldn't have, what happens then? Should it report? Should it report the US bank? Should it self-report? As I say, it's extremely complicated, fact-specific issues, which normally arise in circumstances where, as Dave says, the consequences of getting this wrong are severe. And facilitation for lawyers as well. You know, I'll flag the dreaded word facilitation, because, as I say, even though you may not think you're directly subject to US or EU sanctions, if you do something that facilitates, that can fall foul of them. And certainly that's an issue for lawyers. If we are involved in a deal which we believe is breaching sanctions, we would certainly have to drop out and leave the client to it. Last quick example, because I'm running over time, but for parts suppliers, when we're supplying parts, remember we said it's in breach of sanctions to make an economic resource available. Well, if you're a parts supplier and you're supplying to this structure which had no connection at all with the EU, a Turkish operator, Cayman SBC, high net worth individual, let's call him Russian, but you're making parts available to that operator, knowing that that Russian is a sanctioned individual, you know, that parts supplier could be in trouble. That's indirect making a resource available. And we haven't even gone, it was on Dave's slide, but one of the biggest issues we have in practice, but I haven't mentioned it because it's not so much business jets, we haven't even gone into a situation where you're dealing with an aircraft which has more than 10% US value equipment on it. Because, let's face it, almost every single aircraft in the world does, or you're never going to find somebody that's willing to say, oh yeah, that aircraft, don't worry about it, it's 9% US value equipment, so go and lease it to Iran, who cares? You know, that situation just doesn't arise.
Scott. All right. Okay. Well, that's great. Well, I have another slide. Well, there we go.
So these are the last two questions I think Al had in his presentation. I think they're good ones in terms of, so what do you do if the client breaches the sanctions? And so, firsthand experience, you verify the facts with the client. Unfortunately, clients lie, particularly in these situations. I'd say about half of my clients lie to me about what they've done. I'm serious, right? It's worse than kids. You catch a kid in a cookie jar, like, what the hell are you doing? You're stealing. No, it's just, they lie. It happens, and you have to take that into consideration. And so you just tell them very, very tactfully, look, I'm here, we are protected by attorney-client privilege, tell me what happened. And in a scenario that I said before about the client going for the grand jury, she had everything. She was the accountant for the company, so the government knew who they were dealing with. And that's why they let her go. And I said, are you sure you don't have any information that you need to provide at this point? I have nothing. She got on the plane and gave him everything. Downloaded 5 years of all records. I mean, it's totally busted. Totally. I looked at the record, I'm like, you're done. You're done. Verify the facts. Confirm the accuracy of the allegations. Call OFAC. Call BIS. Ask informations. If clients are lying to you, and if you convey that information, everything you say, my client told me, I don't represent anything is true. My client told me this. And when the people in the government come back and say, you need to ask your client again about what really happened, then you know you're in trouble. Then you need to determine whether or not you want to proceed. But research, after you talk with the client, get the relevant facts, research the applicable regulations and law, understand how bad it is, whether it's, you know, the US or EU, develop a strategy, look at worst case scenario. Worst case scenario, basically, look, I'm sorry, I can't help you. You're in a world of hurt, and, you know, good luck with this. I'm going, I'm done. Assess the likelihood of criminal, civil, and asset forfeiture grand jury. If your assets are seized by the government, the U.S. government, whether it's an aircraft, engine, parts, etc., chances are you're never going to get them back. They're going to be sold. They go to customs, and they get sold off immediately within 90 days or 180 days. Determine voluntary disclosure is an option. It's better than nothing if it's an option. Anything on this? Different perspective?
I think just assume the government knows it was going to find out as much or not, if not more, as we do, or your client does even.
Right. Because
they have their sources, and in that case, voluntary disclosure probably is, if in Dave's example, this individual has actually breached sanctions, voluntary disclosure is probably the best option because there's really no coherent way out.
Right. And so, I hate to say it, but we're picking on Huawei here. So if Americans are going through the airport and see this great deal on a Huawei phone, don't buy it. I just want to throw that out there again. I was just thinking about that in my head.
That's the one message from today's event.
Right, that's a classic one. That'll get you in trouble. You're like, I have nothing to do with aviation. And then, one more. And what happens if your client is on the list? And I'll refer to either entity list, denied persons list, SDN, any of these lists. So you go to that search engine for the United States, you type in a name and you see it pop up. Never a good thing, right? So same thing. Get the facts. Avoid discussing with anyone until you're able to understand what you're into. How bad is it? Because if it's really bad, you may just have to walk away. Develop a strategy, and the same types of things. The only thing I'd say is start drinking heavily, right? that's my best advice.
It's worth reminding for charter brokers, of course, that if somebody, as we said, there are travel bans. So these individuals, especially designated individuals, are banned from traveling. So if they book a charter with yourselves, then you need to be checking the lists to ensure that people who are trying to book charter flights are not actually banned from flying.
Right.
And I assume all operators do that. Certainly, the operator clients that I've got do that. But as I say, it can be difficult because the lists have names with variations of spelling, and or the flight might be booked by somebody else, and then somebody else actually turns up to take the flight. But breaching a travel ban by flying an individual is certainly a facilitation of a breach of sanctions.
Right. And the funny thing, I think lawyers do this, the risk of estimate thing. So we watch the news, and literally this morning, as it happens, so I'm watching, and this kind of hits close to home for folks. I'm watching what's happening in Hong Kong, and if that explodes, get ready for the sanctions on the U.S. government side. And so if any of these registries have, or people are operating and aircraft that are on the list because of what's going on in Hong Kong or other places, be prepared because it may happen. Yeah. The same thing with Russia. It happens. The Iran nuclear deal, that exploded, and people got on the list. Yeah. So if you have planes for the registries that are here, if you have aircraft on the registries, have a plan B because they can't pay you in dollars. And pistachios don't work that well, right? So think about that.
I think it was Clausewitz who said, warfare is the development of diplomacy by other means, but nowadays really it's economic warfare. Economic warfare is the way that great powers are going to be exercising their power in the future. It's not via conventional military means, which is good for the UK, of course, because we don't have conventional military means anymore. We're not going to be sending an aircraft carrier to China because we've only got one and it hasn't got any aircraft, but. If 100 years ago, I'm sure we would have delighted in doing that sort of thing. But in this day and age, Dave's in a fortuitous position because he's from Top Dog Nation. We used to be Top Dog Nation, but I've got very accustomed to no longer being top dog. But the advantage of being top dog is that your currency is also top dog, and you can weaponize your currency. Yeah. And let's face it, that's what sanctions are, and that's effectively what the United States is doing. It's weaponizing its economic power, and it's weaponizing its currency, and it's using the dollar as a weapon to force other nations to comply with what it wants in strategic global economic blah blah terms.
Not my fault.
And I'm not saying it's right, and I'm not saying it's right. I'm not saying it's wrong. It's just the way it is, and we have to get accustomed and live with the way it is because, as I say, when you're top dog, you can rule the roost and behave accordingly. Nothing wrong with it. We'd do it if we could.
Great. I have one quick question. Both of you touched on the potential liability for the lawyers involved, and of course we're all worried about the clients. But what about other people that might have a potential liability? Brokers, other advisors? Do you see that happen where they're entwined in this and drug into the process?
Yeah, no, for sure. As we said, there's the strict law of the sanctions regimes, and then there's the dreaded word facilitation. And anybody who's involved in anything that's got any sanctions-related connection whatsoever needs to think about their role in that transaction. So if you're a broker, I guess it's a slightly unlikely scenario, but if you're a broker and you see an aircraft being sold to a Russian who's on the sanctions list, and that Russian's paying dollars, again, a bit unlikely, but and you just sit back and let it happen, well, you've got to have serious concerns about that. That is facilitation. I'm not saying you necessarily need to be ringing up OFAC to say, oh my God, OFAC, look what's going on, but they'd certainly have to drop out, I think.
Yeah, and that's a good point. I mean, so a lot of the U.S. sanctions, they're focused on Americans, but if you're an American working in a non-U.S. company, it still applies to you. You're an American just because you're working in a foreign company. But in terms of facilitation, I think, I remember vividly walking back at eBase, I was walking back from the Credit Suisse event, and I got a call from the folks at BIS and said, David, we're just going to give you a heads up, in a couple minutes, your client's going to be put on the entity list. And thanks. There's really nothing I could do at this point, but that's how quickly it happens. So you've got to be prepared. I did start drinking heavily after I got that call, but that's the thing. Everybody is impacted, and you just got to research and figure out how bad it is, or is it bad at all.
Yeah, I'm getting very concerned both about Dave's client base and his drinking habits, but I guess that's for another day. But
this is the worst.
But it is worth stressing again that, as Dave says in that example, you can be. So I've got a client that's a UK company. But it's got three directors, 2 of them are US citizens, and 1 of them is a UK citizen. So that company cannot breach sanctions, even as a UK company. So it might be okay under UK and EU regimes, but it cannot do anything to breach the US regime because it's got 2 US directors. And there are sections of the regulations, of the OFAC regulations, which say those directors can recuse themselves from non-compliant transactions. But frankly, is that a good idea? Does it even work? Because if those 2 directors recuse themselves, that company then it's only got 1 sole director that then can't given proper authorization. It's always worth considering any US connection. Yeah, I guess the message for the day: any US connection with transaction nexus, directors, citizens, etc., wherever you are, is going to be caught.
Okay, great. I think we're out.
That's your message, isn't it?
Great, thank you.